B, and this is the formal lecture, if you like, for week 4. So we're doing things a little differently today. For the first 3 weeks, we had our live sessions, and that was, if you like, the formal lecture / tutorial. This week, I'm pre-recording the material for 2 reasons. The first is that your first assessment, of course, as you know, is due on Thursday, the 13th of August. So by preparing material now about my thoughts in relation to weeks 1 and 2 in particular, you have a better opportunity to finalise your material for that assessment. The second, and just as important a reason, is that on the standard Thursday night session, which will be for this week, and that will be the 6th of August 2020, as I foreshadowed, I'm handing it over to you. It's, if you like, the flipped model of learning on steroids, for want of a better term. The university adopts an approach of providing you with relevant materials and encouraging your learning in a proactive manner. So on Thursday, the 6th of August, I'm inviting you to take control of the session. I'll be taking a very much a secondary role in the proceedings. May not be there for the whole session, but what I'm going to do is invite you to, as it were, take control and contribute something. That session is not going to be recorded, so it's entirely your session. If you can't make it, then feel free to create your own sessions with people that you're joining in study groups in this university course. I'm keen for you in first year to create some contacts with each other, to develop some self-learning skills and learn from each other as much as learning from yourselves, from your own individual learning and research. I am heartened that this week there has been an increase in the level of collaboration, which I think has been missing for the first 3 weeks. So please continue with that. And part of my rationale in handing the session over to you this week is to encourage you to continue to do that. Now, the first assessment is, of course, due on Thursday, the 13th of August. So today, I'll provide you with, I trust, all of the formal material that you need to complete that assessment. I'll deal with misrepresentation, misleading conduct, and the other issues around week 2 material that we're finalising. And I'll also deal with the week 3 material that deals with Estoppel. And the week 4 material we'll continue with after that time. So the material that I'm talking about isn't directly, of course, in sync with the formal weeks. And part of the reason for that is that we have, in essence, 2 weeks up our sleeve, weeks 11 and 12, week 11 not examinable. By now, I trust that you're well advanced in your preparation for the first assessment. And you should certainly have read the second assessment, and you should be formulating some thoughts and checking the technical side of how you produce your work for that second assessment. I would also hope that you're preparing for the third assessment, the take-home paper. As you know, that paper is released on Friday, the 16th of October at 5 p.m. and it's due the following day, Saturday the 17th of October at 5 p.m. The maximum word limit is 3,000 words, and for that assessment there is 50 marks allocated. I will provide you with 3 questions. Question 1 is a hypothetical scenario. It requires you to reflect on the work that you have completed over the full 12 weeks, although having said that, week 11 material is technically not examinable and week 12 is revision. But I will ask you to provide a reflection, a commentary, and your job is to consider case law, legislation, general principles, and other material that may be relevant to issues around contract law. There is a 1,500 word limit on that question. Now, questions 2 and 3 are of a different style. They're essay style questions, and you should respond to some of the questions that sub-questions that I provide if relevant, and and that's to assist you in answering the questions. But ultimately, it's a matter for you to determine what's the best way to approach the particular essay style questions, as indeed it is for the hypothetical scenario, which is question 1. When you prepare your work in preparation for the assessment, you should consider what I call the level 3 preparation techniques that I describe in the video, which you'll find somewhere in Moodle, about preparation for examinations and short window assessment. Now let's continue with our discussion around week 2 material, which is misrepresentation and misleading and deceptive conduct. We've talked about the flow chart, some of the basic principles. We've talked about Hedley, Byrne and Heller, and that leads us to the more general discussion around damages. So damages is, if you like, the second form of remedy that courts will allow for misrepresentation, and damages is essentially a payment of money. But there are 3 things you need to understand about the payment of damages for misrepresentation. Now, first, tortious damages are only available where there's a conduct of a tort, and that is, as we discussed last week, in the context of misrepresentation, only fraudulent and negligent misrepresentation. Now, some statutes do allow claims for damages for innocent misrepresentation, but essentially, innocent misrepresentation is not one where damages is applicable as a general common law rule. I mentioned legislation, and today we will talk about some important pieces of legislation that you should consider within the context of answering any problem related to contract law. Now, the second point about damages is this, that when they're available, they may be awarded in addition to rescission. So for fraudulent and negligent misrepresentation, courts can award rescission and damages or either of those. And finally, now this is a fine point. You will need to distinguish between rescission, damages in tort, and damages in contract, because they are different. So we know that rescission is an equitable remedy. And we know that the aim of rescission is to essentially unravel the contract completely. So it's what we call ab initio, to have the parties, well, more particularly the innocent party, be best placed back to its original position, which is pre-contract. Now, damages in tort aim to compensate a plaintiff for the prejudice or disadvantage suffered due to altering their position as a result of the inducement that they acted upon through the defendant's misrepresentation. So it's sometimes said the aim of tort damages is to place the innocent party back where they would have been if the tort had not occurred, which is pre-incident position. Now, damages in contract aim to place the innocent party in a position they were anticipating as a result of the contract. That is, the financial benefit they would have obtained if the contract had been successfully completed. So we look at the damages in contract, if you like, from a post-contractual position. So if rescission and damages are being claimed, then it is not damages in contract, but damages in tort that may apply, and you'll need to give some consideration for that. I appreciate those of you that haven't studied tort will say that puts us at a disadvantage. I can only really identify that there is that issue that is relevant because I would be remiss if I didn't draw the distinction now. And it may be that in your study of torts, the distinction is being considered from that perspective as well. And as you probably know, I have a great interest in the general law of remedies, and that is a unit that was, if you like, under construction pre-COVID, and I was hoping to be involved in the construction of that unit. It may still happen, but if it does, it would be an excellent one to look out for as an elective. So for damages to be awarded for misrepresentation, there needs to be more established than merely a misrepresentation. As we discussed last week, there must be an ability of a plaintiff to show that there was a misrepresentation. It intended them to act on that misrepresentation. They must show that they did, that there was a reliance, and they must show that there was harm. We talked about that last week. Now, I mentioned that I'll introduce some statutory provisions, and the first one that I want to introduce for you to consider today is Queensland-based legislation, and there will be counterparts interstate. But for Queensland, please look at the Civil Liability Act 2003. And for the sake of today, I'd like you to consider sections 4 and 5 only. Now, section 4 of the Civil Liability Act is really very simple. And it simply says, subject to what's said in section 5, this act applies to any civil claim for damages for harm. It's very broad. Section 5 says what's excluded from the Act, and essentially you'll see when you read the Act that it excludes injuries for compensation in relation to work cover matters, injuries for compensation under workers' compensation and rehabilitation, and injuries for dust-related conditions or injuries relating from smoking or use of tobacco product. So really some employment and tortious areas aside, the Civil Liability Act has very broad approach. Now, one case to assist in highlighting all of this is Jones and Dumbrell. It's 1981 VR, which is Victorian Reports, which is an authorised set of reports, page 199. Have a look at that case and you'll see it relates to the manufacturer of children's toys. And Jones was one of the company founders. He'd been joined by a small number of other partners along the way. Dumbrell sought to purchase the company. Jones was looking to retire, and Dumbrell said to Jones, look, I intend to purchase the company as a going concern, and the Dumbrell family will operate the company. And Jones was therefore attracted to the idea of the company remaining a family company. And Dumbrell was therefore able to negotiate on favourable terms. The court did not ultimately decide whether Dumbrell ever intended to operate the company as a family business, but before the time of the contract was formed, he had, according to the evidence, decided to purchase the company for resale to another corporation. He didn't tell this to Jones. Indeed, he took steps to ensure that Jones couldn't find out. So when the sale went ahead and the resale followed, Jones sued. The misrepresentation was clear. Dumbrell made a statement. It was a statement of fact, which he knew to be false. So there is a misrepresentation. And what question is it fraudulent misrepresentation? So think about the key elements. Did Dumbrell intend for Jones to act on the representation? Clearly, it would seem he did. Second, we ask, did Jones act on that representation? Again, based on the evidence, it seems clear he did. And finally, was there harm? Now, at the start, you might say, well, there's no harm. Jones got what he felt was a fair price. But the court saw it differently and said that when Dumbrell sold the business for a higher price than he paid for it, had Jones known of that, he might have expected to share in that profit. So therefore there was a loss to Jones. And as a result, the court held in that case that all elements supporting damages for fraudulent misrepresentation are present. Now the reason I'm mentioning that is that it's a case that highlights the thought process that you should adopt if you're dealing with answering a problem of that nature. And it's worth looking at the judgment. So what are some of the key thoughts then? The purpose of rescission as a remedy for misrepresentation is essentially to return the parties to their prior contract position. But damages may be awarded for fraudulent misrepresentation and negligent misrepresentation, and there is that basic distinction between contractual damages or tortious damages. Now, what are some of the important other statutory provisions you need to consider? Well, You'll recall that there was, in 1974, the enactment, which was a watershed enactment of the Trade Practices Act. As we discussed last week, please don't cite the Trade Practices Act if it relates to a matter that is beyond 2010, which all of the questions will be, because the Trade Practices Act has now been re-legislated as the Australian Consumer Law, and you'll find that, and I asked you this last week to find this for yourself. If you did, well done. If you didn't, here's the answer. You'll find it as Schedule number 2 to the Competition and Consumer Act 2010, which is a Commonwealth piece of legislation. But it is a little more complicated than that. The Federal Competition and Consumer Act applies to laws of the Commonwealth. And of course, there are restrictions in the Constitution about the extent to which the federal government can legislate for such things. It essentially means that federal legislation applies to corporations. So we know that if we look at section 51, subsection 20 of the Constitution. It only applies to natural persons as opposed to corporations in relatively narrow provisions of section 6 of the Act. So have a look at your text at paragraph 13.340 in that regard. So how did the Commonwealth get around that issue? Well, we could have changed the Constitution, but that's a bit difficult. Because this was all organised through COAG, essentially the states created mirror image legislation, and in each state act there is something that is essentially the Australian consumer law, but adopted in the state legislation. So for Queensland, have a look at the Fair Trading Act 1989, and the important provisions are Section 3, dealing with the objectives, Section 4A, the application of the Act, 4B, reference to the Act or particular provisions of the Australian Consumer Law, Queensland, and Section 16, which is the application of the Australian Consumer Law. And it's an important piece of legislation. Please have this if the question is asked of you, what is your authority for applying these ACL in a state-based jurisdiction? Section 16 of the Fair Trading Act, Queensland, says the Australian Consumer Law text, as in force from time to time, applies as a law of this jurisdiction, Queensland, as so applying may be referred to as the Australian Consumer Law, Queensland, and as so applying as part of this Act. The section has effect subject to sections 17, 18 and 19. So please keep the ACL in mind. Now, the ACL is so significant in this area of law that whilst I do want you to understand, know, and be willing to advance arguments in relation to common law misrepresentation, bear in mind that in practice, most complaints now that relate to misrepresentations will be brought under Section 18 of the ACL as misleading or deceptive conduct. So even though I've invited you to go through Jones and Dumbrell and work your way through it, remember, and this is critically important, Jones and Dumbrell was decided pre-Trade Practices Act. It was decided pre-ACL. It was a case that dealt purely with the common law approach to the problem. Now we have the ACL, we have the statutory provisions, state and federal. So in essence, that will be more than likely your lead argument if you're arguing anything about misleading conduct or misrepresentations generally. Now that means we have a bit of a problem for the first assessment, because I've given you a problem that deals with these common law issues in the knowledge that the ACL is critically important, and we don't deal with the aspect of remedies formally until weeks 9 and 10. Week 9 deals with damages, and week 10 deals with restitution, equity, and the ACL. Think back to what I mentioned in week 1. I do want you to concentrate the first assessment, largely on the work that we do in weeks 1 and 2. But I do want you to consider panning ahead and taking a more holistic global approach to the problem. So if you introduce material relating to the ACL, if you see fit to assist you in answering question 1, thank you very much. That would be great, but I appreciate that I'm asking you to do something where I haven't formally introduced that to you. I'm simply referring to it in the notes and alerting you to the overall importance of that. I guess we all look at things differently. Can I just say this? When I took statutory interpretation for this university, and I've done that for quite a few units, I actually reversed the usual approach. Like when I went to uni and we did statutory interpretation, it was all about, you know, the mischief rule, the golden rule, the literal rule, and we did that. And then right at the end, the lecturer basically said, well, that's not necessarily the way we actually do things in practice anymore, because, you know, this and that. Later, we had the introduction of a Project Blue Sky, and the purposive approach was more formalised. So when I teach statutory interpretation, I basically say at the start, this is the way in which it's conducted in practice, and then go into some of the history and talk about the golden rule and the mischief rule, etc. So a slightly different approach. So it's a little like this here, in that I'm stressing the importance of the statutory provisions, but we do want you to have that answer in for the first assessment. I hope that makes sense. Now, the basic principle then is that under the statutory provisions, you need to consider the basic principle, and it's illegal for businesses to engage in conduct that misleads or deceived or is likely to mislead or deceive. And we deal essentially with deceiving consumers or other businesses. And it applies even if you didn't intend to mislead or deceive anyone, or even if no one has suffered loss or damage. So already, some of the common law rules don't apply to the basic principles and basic operations of the statutory provisions. I hope that makes sense. So in addition to prohibition against misleading or deceptive conduct, it's unlawful for a business to make false or misleading statements or claims about goods or services. Now, when deciding whether conduct is misleading or deceptive, the court will consider the position of the person to whom the representation was made, and then consider whether the conduct complained had the tendency to lead the person into error. What that means is that essentially it's an objective test, but considered from the standpoint of the individual in those current circumstances. The case you need to refer to as your authority for that proposition is Campbell and Back Office Investments, Pty Ltd, 2009-238 CLR 304. Have a look at your text at 13.16.7. Now, given that much of the unit as I'm presenting it relates to the remedies that are available to you, you need therefore to consider what are the remedies that are most likely to be relied upon and offering the most substantial benefit if someone alleges that a person or a corporation has breached Section 18 of the ACL. Have a look at sections 236 and 237 of the ACL. 236 deals specifically with actions for damages. And if a person, the claimant, suffers loss or damage because of the conduct of another person, and the conduct contravened a provision in Chapter 2 or 3, which includes Section 18, the claimant may recover the amount or the loss or damage against that other person involved in the contravention. Now, the court may also order such orders as it thinks appropriate for someone who has suffered or is likely to suffer because of misleading or deceptive conduct. So have a look at Section 237, because it opens up a wide range of potential remedies that may be available to you in those circumstances. So do read those sections carefully, and you'll see that there is a reference in section 237 to sections 242 and 243. So even though I'm saying there's a broad range of orders that may conceivably be available to a court pursuant to section 237 of the ACL, the type of orders that may be made under section 237 of the ACL are actually listed in section 243. Now, for example, the court may make an order making a contract void ab initio, or from a date, or to vary the contract, etc. So the orders that are listed in 243, the kind of orders that a court may make in these circumstances is really quite extensive. I won't read them, but I do urge you to look at that and think about carefully whether the ACL applies. If it does, has there been a breach? If there is there a remedy under 236, damages, or 237 broader? If 237 does apply, what kind of order under 243 do you think you should argue before the court in seeking the remedy that you claim to have? There's a lot of material there, but it's logical. So have a look at that. And remember, of course, that a party claiming remedies must have suffered because of the contravention of the ACL. So again, we still need to think about those issues of causation and remoteness. So the principles in Headley, Byrne and Heller still apply in terms of the statutory provisions, certainly in terms of the general logic. Now, there are important provisions that relate to consumer protection. And one of the key aims of the ACL is to prohibit representations that are maybe involved in sharp or slightly shonky business practices. So have a look at section 29 of the ACL that deals specifically with false or misleading representations about goods or services. So what are some of the key points then regarding the ACL? For the purpose of section 18 of the ACL, there are a lot of things that may become a trigger. It may be physical actions. It may be written words. It might be oral words. It may be even silence or conduct. So silence under the ACL can amount to engaging in conduct that is misleading or deceptive. And in that regard, have a look at the expansive definition of silence in section 2, subsection 2 of the ACL. So when you're trying to put all of this together, ideally you'd be creating this toolkit for yourself, which identifies key words, phrases, sections of legislation, relevant case law, maybe examples. And you'll probably come to the conclusion that certainly under the statutory regime, misleading and deceptive conduct and misrepresentation are essentially the same thing. So under the statutory provisions, misrepresentation relates to, misrepresentation generally relates to the body of common law and equity that deals with protecting parties from innocent, negligent, or fraudulent misrepresentation, as we discussed earlier. But misleading and deceptive conduct relates to statutory equivalent of that same behaviour. That's why, even though it's a little out of order, I'm bringing in elements of weeks 9 and 10 now, just to give you a taste to help you through the logic of all of this. So you'll see that the ACL provides a wide range of remedies, including compensation in circumstances where someone has engaged in this misleading or deceptive conduct in the course of trade or commerce. The ACL does go far beyond the general law in relation to the conduct, and it may include punitive sanctions. So where parties negotiate contract, they're not at liberty to simply mislead one another to gain an advantage. You need to bear this in mind. There's a difference between assertive negotiation, now that's allowed, but outright misrepresentation will usually entitle the innocent party to obtain some protection from the court. And remember that to some degree the ACL does apply against individuals who are not corporations. Have a look at ACL section 6. I mentioned the issue of silence. You'd probably need to have an authority on this and some guidance. So have a look at Johnson Tiles Proprietary Limited against Esso Australia. It's a federal court case, 1999, FCA, Federal Court of Australia, 477 at 4. Justice Merkel said, where the relevant conduct involves the supply of goods or services in circumstances where there is an omission or to impart information relating to the particular quality or aspect of the goods or services, silence may be the element that renders the conduct in question misleading or deceptive. All right, so that's all that I propose to talk about in the context of misleading or deceptive conduct and misrepresentation. Let's move on to week 3 material, Estoppel. Before I do, can I just say that there are some excellent materials available to you in your text in Chapter 7 and the casebook, if you have it as well, Chapter 7. Now, when it comes to Estoppel, there are some key cases. I'm going to select 2. One's more important than the other. The first one is High Trees House. You'll need to have a look at that case. And the second, and this is the most important case on Estoppel. You really can't answer an Estoppel question without referring to this one. It's Waltons and Marr. So we know that for misrepresentation or mistake to apply, there must be a contract, at least at common law. But a party may mislead another party in another way that causes considerable harm to them. And that can be done without a contract. So what if, for example, this happens? One party misleads the other into thinking there's no need for a contract, where in fact a contract would be necessary to protect the rights of both parties. This is where the law of estoppel comes in. And it's important because throughout your study of the law, you'll keep hearing references to estoppel. You'll hear that in property law. You'll certainly hear it in civil procedure. It'll just crop in. You'll even hear it in aspects of criminal law. So you need to understand what estoppel means generally. So it's a general category of legal circumstances where someone is prevented from departing from statements which they or the courts had previously made. So estoppel means to stop or to bar or to hinder, resulting as a result of what somebody said or caused them to do in a certain way. So as much as possible, the law tends to think of estoppel as a uniform doctrine operating consistently in both law and in equity. And the important case that's authority for that proposition about the all-embracing nature of the principle of estoppel is Commonwealth against Verwayen. That's Verwayen, and that is 1990, 170 CLR 394, often called the Voyager case, and that's an important one to consider. Excuse me one sec. So when we talk about estoppel, I mentioned there's a wide range of ways in which it's used. And in your notes, you'll see that there's estoppel by conduct, promissory estoppel, representations, estoppel by record, common law estoppel. There's Anshan estoppel, which is based on the decision of Port of Melbourne Authority against Anshan Pty Ltd, 1981, 147 CLR 583. That's actually an important case. I'll just stop there before I move on to other forms of estoppel. In the Port of Melbourne Authority in Anshan, or the Anshan case, this thing of Anshan estoppel was created, and it basically means that if a plaintiff has a claim, they're entitled to bring it to court, but only one time. They have one bite of the cherry, so to speak. And in this case of Port of Melbourne Authority in Anshan, both parties had earlier been found liable in negligence as defendants in an action that was brought by a dockyard worker. The dockyard worker was injured because of the negligent operation of a crane by Anshan, and Anshan was using the crane on hire from Port of Melbourne Authority. So both parties were involved, both were found to be negligent, and the liability in the previous action was 10% blame to Anshan, 90% blame to Port of Melbourne Authority. So despite that fact that those two parties were sued by this dockyard worker who'd been injured, at a later time, the Port of Melbourne Authority sought to enforce a clause in the hire contract against Anshan that made Anshan fully liable for all actions arising from Anshan's use of the crane. Now, of course, as was obvious in the court, the Port of Melbourne Authority could have pleaded this in the previous action so that when the court was considering the apportion of liability, it could have realised that and made a decision based on that information. So the question is, can Port of Melbourne Authority re-agitate this, having already been involved in this litigation as defendants with Anshan? And the High Court held that the new claim was estopped from proceeding as a result of a cause of action estoppel. And the court said that the new claim was so closely connected with the subject matter of the action that should have been dealt with in the defence of the claim that the Port of Melbourne Authority can now no longer bring it. So it's an important instance of where estoppel is used in a practical sense. Now, you'll also come across estoppel as common law estoppel or equitable or promissory estoppel, which is very important. And equitable or promissory estoppel enforces gratuitous promises. And when we talk about estoppel in Contract B, even though there's a whole wide range of it, we'll generally be talking about equitable estoppel. So what do we mean by this equitable or promissory estoppel? That brings us then to Walton Stores and Marr, the key case. 1988, 164 CLR 387. And in this case, the High Court established that equitable estoppel may apply more broadly than was previously considered, in that it may apply in the absence of any pre-existing relationship of any kind. So what happened is this, and this is the key to this case. Waltons induced Marr to believe that an offer would not be revoked. So there were discussions between the parties, but there was no formal legal existing relationship between the parties. They were in discussions. So the court decided that there are 6 key elements. There must be a representation. Usually that's by words, but doesn't strictly have to be by words. Number 2, the person making the representation must induce the other party to rely on that representation. Number 3, the person to whom the representation was made must rely on that representation. Number 4, the representor must know the person is relying on the representation. Number 5, the representee's reliance on the representation must result in them incurring some detriment. And number 6, the representor failed to act to avoid that detriment. So they're the key 6 areas. If you're answering a question based on estoppel, you've really got to talk about those things. So what it means is the approach of the law is to stop the representor from resiling from their representation. That is, in a way, you could say that the law assumes that the case must proceed on the basis that the representation was true, even though it wasn't. And the consequences then fall to the party that made the representation, in that case, would fall against them. So I mentioned that there are some key cases. Just to give you an idea of the historical development, it goes from Hughes against Metropolitan Railway in 1877 to High Trees House in 1947, and then it goes to Walton Stores and Marr. As is my style, as I mentioned earlier, I like to tell you what the current law is and then maybe talk about how we got there. So in Hughes and Metropolitan Railway, it was a 99-year lease, and in that lease, tenants were to complete repairs and maintenance on a building within 6 months of being informed by the owners of the need to do that work. There was the notice in this case given in April 1875. The lessee offered to buy the building outright, meaning it was no longer required to meet the deadline. There were negotiations until December. They broke down. There was no repairs and maintenance undertaken, and because the work had not been done, the owners sought to evict the tenants, and the courts basically said, well, no, you're stopped from doing so because your involvement in the negotiations was such that it's reasonable to assume that the deadline had been suspended as a result. So there's that's Hughes and Metropolitan Railway, and then there's Birmingham and against North Western Railway, and then there's Central London Property Trust against High Trees House, 1947, KB King's Bench 130. So what happened in High Trees House? Well, the Property Trust rented a block of flats to High Trees in 1937. And of course, the Second World War broke out, and High Trees negotiated with the Property Trust, which agreed to accept rent at half the original rate. A little similar to what we're seeing right now with the pandemic and the negotiations that are being conducted between landlords and tenants right around Australia and probably around the world. Anyway, in High Trees House, the agreement to reduce the rent was reduced to writing, but was not an amendment to the original contract, and it was not supported by any specific consideration by High Trees. Now, at the end of the war, the Trust sought to collect the rent at the original rate and sought to collect the arrears based on the fact that High Trees House was only paying half the rate. The case came before His Honour Denning, later Lord Denning, who drew both on Hughes and Birmingham to advance the law, but he developed an underlying rationale, and this is the important rationale. He said that the Property Trust had effectively made a promise in circumstances where it made it clear that it intended the promise to be legally binding, and that High Trees House had relied on that promise, and the Property Trust knew that High Trees House would do so. So therefore, it was held to be inequitable to allow the Trust to resile from the promise that was made. And that's basic principle of Estoppel right there in High Trees House. So where a representor makes any representation that affects the legal relations, and that representation was both intended to be acted upon and in fact was acted upon, promissory estoppel will prevent the representor from acting inconsistently with that representation. So in this case, there was, in High Trees' case, there was no cause of action for damages, but really the case was, I want the Property Trust to make good on its representation. But at that stage, it did require a pre-existing legal contract, and it only operated as a defence to a claim. So you can see how Walton Stores and Mars developed that much further in terms of the development of the law. So what actually happened in Walton Store and Mars? So in Walton's, it proposed to purchase some land for its business. Walton Stores were a big department store chain, you know, Myers style. The seller, Ma, agreed to knock down an existing building and build in its place another building to the specifications sought by Walton's, so specific to Walton's. Now, timing was an important aspect of all this, because for the sellers to meet their obligations under the contract, they could not afford any delays in the transfer of land. And there was a draft contract, but it wasn't signed. So when time began to run short, they sought an assurance from Walton's about signing the contract. And Walton said, yes, the contract will be forthcoming. So Ma destroyed the building, still waiting for completion of the purchase. Waltons underwent some restructure and then sought to delay completion of the sale. And 2 months later, Waltons said, we're not proceeding with the transaction. And of course, Ma had spent a lot of money. Now, as a strict matter of contract law, Ma had no recourse because the contract had never actually been signed, and the obligation to demolish the old building was something that was included as an important contractual obligation. But the majority of judges began their logic with the notion of unconscionability. And you see this word and this theme often in law. So promises made in the form of non-contractual representations may be binding on the representor if it would be unconscionable for them to go back on their word. And if the representor's actions in going back on their word were so contrary to the requirements of good conscience that the court could simply not permit it, then equity would intervene. And the court came up with the 6 elements that I've outlined as the reason for that. So what's the effect of Waltons and Ma? Well, it means that promissory estoppel can occur in pre-contract negotiations. There's no need now for the pre-existing legal relationship. Promissory estoppel could be used to support a claim of an action in contract, not just as a defence. So therefore, it's a landmark case, and it departs from the idea that consideration was necessary, and it says that reliance and reliance did not matter. But there must be the representation, and in most cases in estoppel, it's pretty easy to identify that there has been a representation. But just remember the old common law case of Feldhaus and Bindley that says that silence cannot amount to an acceptance. You'd want to use that one sparingly these days, particularly with statutory provisions around. But you'll see that the key elements, there must be a representation, there must be an inducement, there must be a reliance, there must be a knowing that there was a reliance, there must be some detriment, and there must be a failure to act, a failure to intervene to say, no, don't do that. So what are the remedies? Because equitable estoppel is a creation of equity, the court does have flexibility to fashion appropriate remedies. And I'm leaving aside for a moment the statutory provisions. I'm just talking about the equitable remedies that are available under the common law. The remedy might be an injunction to stop the representor from taking certain actions contrary to their promise. An injunction is an order of a court essentially of one of 2 types. Number one is mostly used to stop something. An injunction can be a mandatory injunction, which is actually a bit like specific performance to force them to go ahead. But mostly when we talk about an injunction, we're saying stop. Other equitable remedies might be compensation to restore the representee to the position they might have been had it not been made. Remember, that's the basis of the equitable remedy, to restore back to the original position. And the remedy may be to refuse to allow the representor to resolve from their promise in one way or another, whatever the result would have been. Okay, so there are a number of key points associated with estoppel, but what I will ask you now is this, and I'd ask you, maybe in your toolkit, but before you move on from week 3 material, you should be able to explain the doctrine of estoppel. You should have an understanding of the basis of the doctrine of estoppel. You must have an understanding of what are the elements of successfully establishing an estoppel claim. You should be able, even though it's a fine difference, have a look at the difference and the similarities between equitable and promissory estoppel. There is a difference. You should be able to ascertain whether equitable estoppel can apply in the absence of a pre-existing relationship, and on what basis can you say that? So what's your authority for the proposition and why? And what is the relevance of the doctrine of estoppel generally to contract law? So there are some key points. We know that estoppel is different now from misrepresentation and the statutory prohibition on misleading or deceptive conduct. We know that Estoppel is concerned with innocent conduct or not so innocent conduct. But ultimately, it's dealing with situations where harm has caused, and perhaps a good way of describing it is that it's concerned with inconsistent conduct. Look, I'll withdraw the statement I made about innocent conduct, scrub that. So promissory estoppel operates where the representor induces someone to rely on certain things and the relying party has changed their position. Valuable consideration, as we know from Waltons and Marr, is not an element of at least promissory estoppel. And in Australia, the doctrine is largely defined by Walton Stores and Marrs. All right, thank you very much. I look forward to your session for week 4 on the 6th of August, and we'll be back for the live or formal sessions in week 5 on the 13th of August. All the best. Bye.